Testing. Testing, testing, audio testing. This broadcast is live. Testing, testing, audio testing. Yep, loud and clear. This broadcast is live. Alrighty, hello there to the suppressed YouTube. We're going over summary judgment and motion to dismiss. We're going to do a quick reading here so we could gather language for the anticipated failures of the defalcators. So if you will, please hit the thumb up upon entry, and everybody let me know where you're tuning in from. If you can hear the audio, please confirm by pressing the number 1. Continue to support this channel by hitting the thumb up and hitting the subscribe button. Alrighty, without further ado, let's get right to it. Hear the audio, please confirm by... Yep, we are on, loud and clear. 735 ILCS 521005 1005. Summary judgment. A. For plaintiff, anytime after the opposite party has appeared or after the time within which he or she is required to appear has expired, a plaintiff may move with or without supporting affidavits for a summary judgment in his or her favor for all or any part of the relief sought. Section B. For defendant, a defendant may at any time move with or without supporting affidavits for a summary judgment in his or her favor as to all or any part of the relief sought against him or her. Procedure. The opposite party may prior to or at the time of the hearing on the motion file counter affidavits. The judgment sought shall be rendered without delay if the pleadings, depositions, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to a judgment as a matter of law. A summary judgment, interlocutory in character, may be rendered on the issue of liability alone, although there is a genuine issue as to the amount of damages. Let me put a disclaimer out here. This is not legal advice. This is here just strictly for entertainment and or education. Please hit the thumb up and don't try this at home. Section D. Summary determination of major issues. If the court determines that there is no genuine issue of material fact as to one or more of the major issues in the case, let's read this one over here. Summary determination of major issues. If the court determines that there is no genuine issue of material fact as to one or more of the major issues in the case, but that substantial controversy exists with respect to other major issues, or if a party moves for summary determination of one or more, but less than all, of the major issues in the case, and the court finds that there is no genuine issue of material fact as to the issue or those issues, the court shall thereupon draw an order specifying the major issue or issues that appear without substantial controversy, and directing such further proceedings upon the remaining undermined issues are just. Upon the trial of the case, the facts so specified shall be deemed established, and the trial shall be conducted accordingly. Section E. From form of affidavits. Affidavit. The form and the contents of a procedure relating to affidavits under this section shall be as provided by rule. F. Affidavits made in bad faith. If it appears to the satisfaction of the court at any time that any affidavit presented pursuant to this section is presented in bad faith or solely for the purpose of delay, the court shall without delay order the party employing it to pay the other party the amount of the reasonable expenses which the filing of the affidavit caused him or her to incur, including reasonable attorney fees, and any offending party or attorney may be adjudged guilty of contempt. Hey, Jen, the hen, how's it going? G. Amendments of pleading. Before or after the entry of a summary judgment, the court shall permit pleadings to be amended upon just and reasonable terms. Amendment or pleading. Before or after the entry of a summary judgment, the court shall permit pleadings to be amended. Alrighty. This is just a quick read here. This is all this is in the Illinois compiled statute. We are also going to be going over involuntary dismissal based on certain defects or defenses. (735) ILCS 52619. Involuntary dismissal based on certain defects or defenses. A. Defendant may, within the time for pleading, file a motion for dismissal on the action or for other appropriate relief upon any of the following grounds. If the grounds do not appear on the face of the pleading attacked, the motion shall be supported by affidavit. Number 1, that the court does not have jurisdiction of the subject matter on the action, provided that the defect cannot be removed by a transfer of the case to a court having jurisdiction. 2, that the plaintiff does not have the legal capacity to sue, or that the defendant does not have legal capacity to be sued. 3, that there is another action pending between the same parties for the same cause. 4, that the cause of action is barred by prior judgment. 5, that the action was not commenced within the time limited by law. 6, that the claim set forth in plaintiff's pleading has been released, satisfied of record, or discharged in bankruptcy. Let's read that one again. That the claim set forth in the plaintiff's pleading has been released, satisfied of record, or discharged in bankruptcy. Discharged. 7, that the claim asserted is unforeseeable under the provisions of the statute of frauds. Oh, we gotta look that up too. Alrighty. Number 8. That the claim asserted against defendant is unenforceable because his or her minority or other disability. Number 9. That the claim asserted against defendant is barred by other affirmative matter avoiding the legal effect of or defeating the claim. So, B. A similar motion may be made by any other party against whom a claim is arrested. I meant to say asserted. Let me pause here for a second. Let's check something. Alrighty. Yep. Loud and clear. Alrighty. Where's everybody currently tuning in from? Alrighty. Section C. If, upon the hearing of the motion, the opposite party presents affidavits or other proof denying the facts alleged, establishing facts obviating the grounds of defect, the court may hear and determine the same and may grant or deny the motion. If a material and genuine disputed question of fact is raised, the court may decide the motion upon the affidavits and evidence offered by the parties, or may deny the motion without prejudice to the right to raise the subject matter of motion by answer, and shall so deny it if the action is one in which a party is still entitled to a trial by jury and a jury demand has been filed by the opposite party in appropriate time. Apt time. So if a jury demand has been selected, has been filed. Hey, Wisconsin. Alrighty. Section D. The raising of any of the foregoing matters by motion under this section does not preclude the raising of them subsequently by answer unless the court has disposed of the motion on its merits, and a failure to raise any of them by motion does not preclude raising them by answer. E. Pleading over after denial by the court of a motion under this section is not a waiver of any error in the decision denying the motion. F. The form and contents of the procedure relating to the affidavits under this section shall be as provided by rule. Alrighty, well, there it is. The short description. I want to thank everybody for tuning in here for this quick reading. Knowledge is the key to success. It's a daily thing. Hopefully you guys be patient and stay tuned because I'm dropping a whole bunch of new things. I visited a couple agencies And I'll be releasing a couple snippets real soon, and then we'll release the full videos possibly in this upcoming week. Again, thank you guys for tuning in. The one who encourages you to audit them.